Okay, hi guys, welcome back to another video with Pratham Test Prep. This is your host Sanjeet Bhatia again with a new video on your legal affairs for your CLAT and AILET of 2022. So if you are new to the channel, don't forget to hit on the like, share and subscribe button because we keep on making a lot of videos for all the law aspirants, right? So if you are not a part of our Telegram channel, do make sure that you subscribe to our Telegram channel. Also, you can see that there are updated news and articles there. There are expert advice from the mentors, and also you can get all the quizzes for free, and you can subscribe to our material for last 3 years for free. Okay, so if you are not a part of this channel, do make sure that you are subscribing to it right now. Now, starting with the legal affairs for the day, I have sorted out some legal affairs. We'll quickly go through them and then you will be free to go from here. Now, starting from the first legal affair for the day that has come up recently is that the Punjab and Haryana High Court has asked the center to make some rules and specific proposals to deal with underage live-in couples. Right. So there are in 21 years is the marriageable age for all the couples in our country. Now there are some couples that might be living from 18 years of age till 21. So they are above the age of required majority. But what is the provision that is required for that? Now there is that court is being flooded with pleas that were filed by live-in couples not of marriageable age. Those were seeking liberty and protection of life. Okay? So the Punjab and Haryana High Court has asked the union government to make these specific proposals to deal with such cases. Okay. Now there is no act that governs such relationship, and once a person has attained the majority in terms of Majority Act of 1875, okay, it would be difficult for a court to refuse such protection. Okay. तो मैरिजेबल एज के भी नहीं है, 21 साल के भी नहीं है, उसके बाद उनको प्रोटेक्शन भी देना पड़ेगा बिकॉज वो मेजॉरिटी अगर उनकी लाइफ को थ्रेट है, सो ये गवर्नमेंट की ड्यूटी है उनको एक प्रोटेक्शन प्रोवाइड करना. और अगर गवर्नमेंट प्रोटेक्शन नहीं प्रोवाइड कर पाती तो गवर्नमेंट को मेजॉरिटी एक्ट के अंदर अगर देखेंगे तो दे आर एलिजिबल फॉर सच प्रोटेक्शन. नाउ यू हैव टू सी how it's going to happen further. Now, what the court exactly said in this regard is that what is purpose to try and ensure that many adolescents with impressionable minds, not actually fully matured, they otherwise technically are of age of maturity as said in the aforementioned act, do not start living together and later start regretting such decisions, obviously also causing trauma to their parents and family, right? So the court is also taking in consideration the social strain that is there in this regard. Okay, so that is also very important because if you are seeing that the person is of marriageable age, then it's fine if they can be given all the points that they are receiving right now, that they can live together, they can get all the protection. But now here there are two acts that are coming hand in hand, right? One is Majority Act of 1875 that is allowing 18 years of age to be considered as the age of majority. But now they have to protect this person. If there is any threat on such a person, or is there any threat on such a living couple, then they also have to protect them. So there is a lot of ambiguity that the court is also following here. And also they're thinking that if they're not of marriageable age, if they are living together, then there is no act which tells them not to. But obviously there are a lot of social strains that are required in this. So there is a lot of confusion. So that's why the court has said that to the government that there needs to be a special provision for people of that sort who are not of marriageable age and are in the live-in relationship. So you know these kinds of social strains and social formulas will change the strain of the society and will definitely help a lot of cultural change coming up in the years ahead, right? So very, very important case for the day, that there has to be a specific proposal for this thing, because now the age of women have also been increased to 21 years old for marriage. So what will be done in this case is yet to be seen by the center government. Now, right to equal pay for equal work is constitutionally enforceable. That's what the Himachal High Court has said. Now, Himachal High Court has said that this is envisaged in the Article 39D of the Constitution, is a constitutionally enforceable right, that there has to be equal pay for equal work. If there is a man, female, there should be no discrimination that has to be done on the basis of caste, creed, gender, religion, anything of that sort. Okay. Now, Justice Chandra Bhushan has said that 39D of the Constitution of India provides for equal pay and equal work. Thus, this right of the person for equal pay and equal work is recognized as a fundamental right by various pronouncements of the apex court, and the law is settled that the right is a constitutionally enforceable right. Okay, so the court has also agreed to that there are certain pronouncements where it has been considered as a fundamental right. So if the court settles this by saying that it is constitutionally enforceable right. Now, the observation was made by adjudicating upon a writ petition filed by the petitioner seeking equal pay at par with another librarian and assistant librarian of the education department. Okay, so there must be a discriminatory behavior that would be done on the wages of this librarian itself. So they have taken up this writ petition in the court, and definitely they would have been provided with a remedy. So you can see that was the prayer of the petitioner, that yes, my client should get this particular relief. They should get an equal amount of pay for the work that they are doing at that place. According to the structure, she's being discriminated. So the court has taken into consideration such an instance, and they have given the order according to that only. Right now, coming to the next case for the day, that is that transgender prisoners face gender discrimination. Right. So now you understand that when they are present in the society, there is so much discrimination that is caused to a transgender person. If they are put up behind the bars, there would be a certain speck of people that are there, and they might not understand the sensitivity of the situation also, right? So there was a PIL that was filed in Patna High Court seeking separate lockup for the transgender people, and the state has to file a response in that. Now, the Patna High Court has asked the state response in such a PIL that was there to create these separate lockups. Now, the PIL was found by a non-governmental organization that is called an NGO, namely Legal Aid Work, that is the Law Foundation. Now, this was a direction that was commanding the respondent authorities to create separate wards and cells for the transgender persons that are arrested under various offenses and languishing in all the central prisons, district prisons, and sub jails situated in the state of Bihar. Right. So this was a very, very gender sensitive step that they have to take. And also they need to realize that there are certain discriminations that the people from the transgender community face in such areas, and in jail definitely that would happen, right? So there has to be a regulatory authority, and there has to be a separate place for them so that they can also be in their comfort zone, and that also helps them to have their own identity, and it does not happen in the normal jail. Okay, so they have asked, there was a PIL, and the court has asked the state to file a response that what do they think about it. Now, coming to the next part is that Dubai has brought in the virtual asset regulation law. So we have seen that there are a lot of places around the world which have come up with cryptocurrencies, and El Salvador legalized the uses of cryptocurrency as you use your credit card, Master, Visa, American Express. So that's how it's going to be. So Dubai has introduced the crypto asset regulation that joins the list of United States, Singapore, UK, El Salvador, and other countries which have brought these cryptocurrency laws. Now, this was passed by Dubai to regulate this new age industry, which is rapidly expanding, right? So if you know that India has also taken up 30% taxation on any crypto transaction that you do, right? So definitely that's something that all the governments around the world are trying to cash on now. Now, an independent regulatory has been formed to regulate the cryptocurrency sector in Dubai. Now, the Dubai Virtual Asset Regulatory Authority, that is VARA, a regulatory body will oversee the development of the virtual asset business environment in terms of licensing, regulation, and governance in Dubai. Now, this aims to establish Dubai United Arab Emirates as a regional and global virtual asset industry destination. As you know that Dubai doesn't have any oil or anything else. They are surviving on sheer skill of business. So definitely they are trying to expand their business by bringing on such steps of recognizing these cryptocurrencies. So that's why they have taken out the virtual asset regulation law, and they have set up this regulatory body also called VARA. Now, these are very important news. You have to see that El Salvador, United Kingdom, United States, these all countries have taken positive steps toward legalizing of cryptocurrencies and their usage, and how far they can take these cryptocurrencies. So there are a lot of factors that they take in their consideration. So Dubai has also taken this futuristic step to recognize such virtual assets. Okay, so you can also read more upon it if you want to, but this is what a basic structure of this regulation law will look like. The next legal affair for the day is the Telecom Dispute Settlement and Appellate Tribunal. What is this and how it functions is that it was established in year of 2000. As you know that there has been 2G scam and a lot of telecom regulatory authority scams. So Telecom Disputes Settlement and Appellate Tribunal was set up in year of 2000 by amending the Telecom Regulatory Authority of India TRI Act of 1997. Okay, this was constituted to bring out this dispute settlement mechanism for telecom sector, thereby strengthening the regulatory framework. Okay, तो अगर एक different tribunal ही दे दिया उनको अपने cases handle करने के लिए, कोई भी telecom industry से related case होगा वो इसी tribunal में जाएगा, right? Like we have consumer protection, we have NDSL, we have a lot of tribunals. Okay, for different things we have different tribunals. So telecom के लिए, telecom disputes के लिए इस tribunal को बनाया गया. Now it adjudicates on the disputes and disposes of appeals regarding the matters like issues of license. All decisions and orders are orders of the Telecom Regulatory Authority of India can be challenged through the appeals in TDSAT. Okay, so अगर ट्राई ने कोई भी आपको decision दिया है, आप उसको challenge कर सकते हो इस tribunal के अंदर. That was the possibility that was there. Okay, now coming to the next part is that the central government has brought broadcasting and cable services under the preview of TRI Act in 2004. ठीक है, so cable TV जो भी आप देखते हैं, that is all covered under the Telecom Regulatory Authority of India Act in 2004. Now, thus the jurisdiction of TDSAT was extended to those services. Now, in 2017, the matters lay before the Civil Appellate Tribunal and Airport Economic Regulation Authority Appellate Tribunal were also brought under the adjudication of jurisdiction of TDSAT, right? So TDSAT has increased with the time, and they have taken other niche areas also under them, and they take care of these regulations and disposal and appeals of under the cases in these types of settlements that are required. Okay, so you need to read more on telecom disputes settlement appellate tribunal also. Now there is a reservation in local body polls that was happening in the state of Maharashtra. Now Maharashtra, in the 73rd and the 74th amendments, provided compulsory reservation for scheduled caste and scheduled tribes and women in panchayat and municipalities. Right now, the reservation for backward classes is left to the discretion of the state government also. Now Maharashtra decided to provide reservations for OBCs in local body polls also. In 2022, the Supreme Court directed the Maharashtrian government to submit the data on the OBCs to Maharashtra State Commission for Backward Classes, that is MSCBC, now to make recommendations to the OBCs in the election to the local bodies. Now the Maharashtra government submitted the report on the data on OBCs to the Maharashtra State Commissions for Backward Classes. In February of 2022, which is this year, the submission was done by MSCBC, where this recommended up to 27% of reservation for OBCs in elections to the local bodies. Now in 2022, the Supreme Court rejected the report because of lack of empirical studies and research that was done by MSCBC. So this was one of the more issues that you can read, there was Maratha reservation and lot of things that have come up during that period of time also. So this was also one of the issues that was going on in the reservation in local polls in the state of Maharashtra, right? So these were the news for the day, guys. Thanks for joining this live session. I hope you were able to understand some of the legal affairs that were going on during this past week. So don't forget to hit on the like, share and subscribe button, and do take care of yourself. Don't forget to wear your mask and use your hand sanitizers, and also maintain social distancing. Do make sure that you are following all the COVID protocols for yourself and taking care of your health. So keep smiling, keep studying, and hope to see you all again on the video on Wednesday, where we'll be discussing some more important aspects of the exams of CLAT and AILET. Thanks for joining this live session. Do take care of yourself, guys. Keep subscribing, and also don't forget to take care and hit on the like button. Okay, bye-bye, guys. Take care and have a nice day ahead.